Good morning. Counsel, can you hear me?
Yes, Your Honor.
Yes, Your Honor.
Very good. I'm Catherine Gardner, and I'll serve as the presiding judge here today for our court case on our docket. With me on my right is Judge Tom Malone, and on my left is Judge Steve Hill. So we'll be the panel deciding your case today. The only case is 125316, the state of Kansas appellant versus Alejandro Martinez Diaz, appellee. May I have your appearances, please, counsel?
Your Honor, the state appears by Senior Assistant District Attorney John Simpson.
Thank you.
Yeah, Mr. Alejandro Martinez Diaz appears through counsel Michael Clark.
Very good. Appellant, you may begin. You have 15 minutes. And do you wish to reserve any rebuttal time?
May I reserve 3 minutes, Your Honor?
You may. You may proceed.
May it please the court. For a quick procedural background of the case, the state charged Mr. Martinez Diaz with the attempted first-degree murder of Javier Romero and Javier Romero's girlfriend, Kaylee Nierbas. Romero testified at Martinez Diaz's preliminary hearing, but then on the brink of trial, Romero claimed, without explanation, that he feared either his preliminary hearing testimony or his would-be trial testimony could subject him to prosecution for perjury. The state offered him use and derivative use immunity. He still refused to testify. And then when the state sought to introduce his preliminary hearing testimony and recorded police statements, the district court ordered that evidence excluded. Its reasoning, as best the state can tell, is that Romero's actions called into question his preliminary hearing testimony. So admitting that testimony would be unfair to Martinez Diaz because the jury would have an incomplete picture of Mr. Romero's credibility. Now, in this interlocutory appeal, the state asked this court to determine whether the party's arguments, the case's unique facts, and Mr. Martinez Diaz's constitutional rights gave the district court grounds to keep Romero's critical evidence from the jury.
Before you get to that, could you address the defendant's assertion that we lack jurisdiction?
Yes, Your Honor. So as this court is aware, the standard for interlocutory jurisdiction is that jurisdiction exists when an order excluding evidence substantially impairs the state's ability to prosecute its case. Now, the argument, as I understand it, for Mr. Diaz is that Martinez Diaz is that the state can prosecute its case even without Romero's evidence because Ms. Nierbas's testimony alone enables the state to make out a prima facie case. But our Supreme Court has told us that an exclusionary ruling can support interlocutory jurisdiction, even if it does not technically foreclose the state's ability to prosecute. In other words, even if it does not prevent the state from making a prima facie case. In this case, excluding Romero's evidence considerably weakens the state's ability to convince Martinez Diaz's jury of his guilt. The state would point out that it has two burdens at trial, the burden of production and the burden of persuasion. And in many ways, the trial is about that second burden. It's about can the state take its prima facie evidence and convince a jury beyond a reasonable doubt that occurred. And in this case, the exclusion of Romero's evidence, there are two reasons the exclusion of that evidence is a substantial impairment to the state's prosecution. The first reason is that Ms. Nierbas's, force of the eyewitness testimony from Ms. Nierbas is considerably weakened. Now, her account is far from unimpeachable. There's evidence to suggest she may have been smoking marijuana right before the incident. Even by her own account, she blacked out mere seconds into the incident. And evidence also possibly suggests that she had a prior abusive relationship with Mr. Martinez Diaz. So in this case, her ability to perceive clearly, accurately remember, and impartially recount the shooting's events are all vulnerable to serious attack. And that's even with Mr. Romero's evidence. But without that evidence, the state's case rests more heavily on whether a jury decides to credit Ms. Nierbas's account.
Counsel, may I ask you a question, please?
Yes.
why is it not possible to submit this? This is not a criminal proceeding against the Romero, correct?
Correct.
It is a criminal proceeding against Martinez Diaz.
Yes, Your Honor.
This man is a witness. Just because he claims that he would incriminate himself and you have granted immunity, why cannot you bring him in front of the jury and let the jury evaluate his testimony? I see arguments made here that, well, he's obviously lying this time or the other time, but that's not up for a judge or for us to decide, is it? Isn't it up for the jury to decide?
Your Honor, it's the state's position that the district court made the determination. Well, that's precisely the case that that in this situation. Well, it's the state's understanding that that was the reasoning for the judge, the court's ruling excluding the evidence. The jury itself needed to be the one to determine credibility. And in this case, the state, first of all, would argue that Mr. Romero's preliminary hearing testimony was constitutionally admissible, regardless of whether the jury was aware of the fact of that he was refusing to testify because of a claim fear of prosecution for perjury. But the state also would argue that the district court had available the opportunity to compel Mr. Romero to take the stand, so that the jury could make those determinations itself based on his conduct on the stand.
Let me ask a follow-up question on that, if I can. Can you hear me okay?
Yes, Your Honor.
All right, now I have the grant of immunity here that you were offering to Romero, and you were offering him use and derivative use immunity. Is that correct?
Yes.
And that's about the most immunity you can offer somebody, isn't that right?
I believe that that's not only the most immunity you can offer, but the only constitutional immunity you can offer and compel a witness to testify.
I mean, I know it's got that exception for perjury, but that's always an exception. The point is, you couldn't have granted Romero any more immunity in this case than you did. Is that correct?
That is correct, Your Honor.
All right, so with that, shouldn't have Romero, he should have been forced to testify subject to a contempt finding, isn't that right?
Well, that is correct, Your Honor.
All right, and if he could have been forced to testify subject to a contempt finding, he's an available witness, isn't he? I mean, he might be refusing to testify, but he's not an unavailable witness in this case. Would you agree with that?
I wouldn't necessarily agree with that. I think the law is clear that if a witness refuses to testify, they are in fact unavailable. Now, you may need to establish that fact by calling the witness and then having him refuse on the stand. But once that occurs and he's held in contempt, he is unavailable.
Then
So-
why even hold someone in contempt? I mean, if someone refuses to testify, that's why we will hold them in contempt. Are you saying that if someone refuses to testify and is found in contempt, then the state can use a preliminary hearing transcript?
That is the state's position, yes.
Do you have any law that would support that?
I believe the state's brief cites cases where the refusal to testify enables it to introduce preliminary hearing testimony. I don't have the names of those cases before me right now. And if the court would like, I could flip through my brief real quick, but I do believe they're cited in the state's brief.
All right, that's good enough for now.
Well, is Romero in custody now for refusing to testify?
Your Honor, I'm actually not aware of the current status, of Mr. Romero's current custodial status. I know the court at the time, when he refused to testify, held him in contempt in order that he be held on that contempt charge. But I'm not currently aware of whether.
You don't know whether he's in custody today for refusing to testify.
Correct.
Because there's all sorts of cases out there where witnesses who have been granted immunity refuse to testify, then they go to jail and stay there until they decide to comply with the court's order. But you don't know whether that exists in this case?
All I know is that the court held him in contempt in order that his time in custody be counted towards that contempt rather than an unrelated pending case that he was charged with. But returning to the district court's decision to exclude Mr. Romero's testimony, one point the state would emphasize is that the district court excluded testimony for reasons that neither party really argued to the court. In this situation, when the state proposed admitting the testimony, Mr. Diaz argued that using the likely perjured testimony would violate due process. The state countered that due process only prohibits the knowing use of perjured testimony, and Romero's actions afforded no basis to regard his prior testimony as perjured. And in this situation, the district court affirmatively found that it couldn't say which one is true. So the district court effectively communicated that it had an insufficient basis to find Romero's preliminary hearing testimony contained perjury. And that ought to have ended the matter, because that was the only argument to address. But instead, the court ruled the evidence admissible. And it did so because it made the unprompted determination that to do otherwise would deny the jury the full picture of Mr. Romero's credibility and be unfair. Because a trial court errs if it interjects and decides a non-jurisdictional and issue sua sponte, the state believes that what the district court did here was reversible error.
So let me ask you, I know the main issue seems to be about admitting the preliminary hearing transcript. Did the district court also exclude the interviews of evidence about his police interviews?
They did. She did, Your Honor.
So does the same analysis apply to both of those things?
Well, I think that the district court's ruling excluding excluding Mr. Romero's police statements was a bit more clear, because she actually keyed her ruling to the party's arguments. And in that situation, she excluded the evidence based under Crawford, so based on a confrontation right sort of analysis. And seemingly when she did so, she distinguished between those statements those statements Mr. Martinez Diaz had actually cross-examined Romero about at the preliminary hearing, and those he had not. But the state would argue that distinction is immaterial to Crawford analysis, in that the confrontation guarantees only an opportunity for effective cross-examination, not the cross-examination prove itself effective in whatever way or to whatever extent a defendant might wish. And as such, if the defendant has the opportunity to previously cross-examine a subsequently unavailable witness about their statements to police, the statements are admissible regardless of whether he or she fully availed herself of that opportunity. And here, there's no argument that Mr. Martinez Diaz not have that opportunity. So beyond that,
Counsel, you have about up 1 minute before you get into your rebuttal time.
thank you, Your Honor. So addressing the police statements, the only other portion of the court's ruling was essentially that because it had already excluded the preliminary hearing testimony, where the questions about the police interview statements were contained, it was thus going to exclude the statements themselves. So effectively, if this court were to find, as the state argues, that the preliminary hearing testimony was admissible, it ought to, so too ought to rule the police statement admissible. And at this time, I would just ask that the court reverse the district court's ruling and permit the state to use Romero's preliminary hearing testimony and police statements. Thank you.
Thank you, counsel. Mr. Clark, you may proceed.
Thank you, Your Honor. I'd like to first point out that Mr. Simpson was not part of the trial team on this case. So to the extent that I suggest that anything that he said that factually is inaccurate, I think that's more just because he's been relying upon transcript and information from other parties and wasn't there personally. So a couple things that I think are worth pointing out in regard to the questions that were asked of Mr. Simpson about the jurisdictional argument that the defense has raised. One, the suggestion that Ms. Nurbis might have been under the influence of marijuana. There's been no testimony or evidence that she smoked any marijuana at any time relevant to this proceeding. The only evidence concerning that was Mr. Romero on several occasions alleged that the reason that they were going to North Lawrence was so that she could smoke marijuana, but there was never any evidence that she actually did. The other thing was there was reference to an abusive relationship between my client and Ms. Romero. In fact, she testified about that during the preliminary hearing and said that that wasn't the case. So the allegation that there had been some abusive relationship between Ms. Nurbis and my client solely came from Mr. Romero. And again, Ms. Nurbis denied that they had a relationship, frankly. She said that they hung out a couple times, I think was the substance of her testimony about the relationship between her and Mr. Martinez Diaz. In terms of the state's argument, again, about jurisdiction and how important or necessary Mr. Romero's testimony was, the state argued that Ms. Nurbis allegedly kind of blacked out or passed out.
Well, counsel, let me interrupt you there for just a second, if I could. I want to ask you a question. Isn't it up to the state to decide how they wish to present their case, and it's not up to some judge?
Absolutely.
So I don't understand why we don't have jurisdiction over this issue. If the state says that this testimony is necessary for the prosecution of this defendant, so we should proceed to hear the controversy. I just don't see where we lack jurisdiction.
Judge, you're certainly much more of an expert than I am on that area of the law, but it was my understanding that in order to proceed with an interlocutory appeal on a court's ruling, that it had to substantially impair the state's ability to present their case. And the state appropriately pointed out that their burden of persuasion is not only to bring forth the necessary evidence, but also to be persuasive. Our argument is simply, there's very, very little, if anything, that Mr. Romero could testify about that Ms. Nurbis can't testify about.
Well, you are asking us to weigh evidence, are you, at this in order to make a jurisdiction finding? We're saying that, well, this is not very important. It seems to me you're asking us to weigh evidence, and I'm not entirely sure that's our function at this point.
Understand, and I guess again it goes back to, if they have evidence to present on that issue, the fact that they want to have cumulative evidence to present on an issue does not amount to substantially impairing their ability to present their case.
I've got one more question for you, and then I'll let you proceed with your presentation. The district judge in this proceeding said, I can just picture hands going like this both ways, saying, I don't know which way is right, which testimony is correct. So what? I mean, basically, why was it her job at that point to decide which version of his testimony should be presented? Why was that? She wasn't in a fact-finding role at that point. It was just a determination of whether or not the witness was available.
And Judge, Before I guess I specifically address that, I do want to state that the defense's position is Mr. Simpson was correct in that if Mr. Romero properly invokes the fifth or is otherwise found by the court to be unavailable because of his refusal to testimony, the preliminary hearing transcript would be admissible. I think Mr. Simpson's right on that regard. But in regard to your specific question, I think Mr. Romero's refusal of testimony and the explanation for why he was refusing to testify put the court in that position. And I understood the district court to be saying, I'm not going to make a determination as to which is truthful testimony and which is not. Mr. Romero, in effect, was stating that he perjured himself during the preliminary hearing by what he was saying when he was refusing to testify. And of course, basically saying, I can't make that determination that he wasn't, that he didn't perjure himself.
So you submitted to the jury, he's already been granted immunity, all kinds of immunity, and let the jury decide which version of events is correct, the first one or the second one where he denies it. You know, witnesses change their testimony a lot, and juries have this wonderful ability to search that out and make a decision. I just didn't see why it was the role of the judge here to discern which version is correct. That's you've answered my question. Thank you. Go ahead with your presentation.
I have a question though, based on your statement about his potential perjury at the preliminary hearing. If that occurred, would he not be immune from prosecution for that under the terms granted by the state in this case?
Judge, I do not read the grant of immunity as giving him transactional immunity for perjury that occurred at the preliminary hearing. It simply allegedly protected him from use if he testified during the trial. So I still think he was at jeopardy of being prosecuted for perjury.
Okay.
But derivative immunity would cover that, wouldn't it? Unless I don't understand the term.
They couldn't use his trial testimony to prove the lack of truth of his preliminary hearing testimony.
Correct.
Because the only thing accepted is, except for the crime of perjury in giving trial testimony, is accepted from the use and derivative use immunity. Correct?
Correct.
Okay, thank you. That's just clarification.
The other problem with, and this was somewhat alluded to during the arguments and the motion hearing in which the district court took this up, was the fact that Romero's preliminary hearing testimony was known to contain falsehoods, and there was no offer by the state to redact any of the false information that Romero had given, even during his preliminary hearing transcript. For example, he testified during the preliminary hearing that the route of travel to North Lawrence, where the main incident occurred, was to basically go up Castle to 6th Street and then from 6th Street straight across the bridge. And in fact, the state knows that because the state has traffic camera footage that shows, in fact, that Mr. Romero's route of travel took him up 11th Street or Haskell. Haskell turns into 11th Street in Lawrence, because there's a video of that vehicle traveling at 19th and Haskell on the way to downtown Lawrence. And in fact, it's very clear that the route of travel that Romero took was not direct and was not the route of travel that he took. And all those things are frankly very important in the course of this case. Want to jump to the issue of the use of the recorded interviews outside of Lawrence Memorial Hospital. That has the same problem in that the state, and frankly, the court knew it at the point that it made the ruling that Mr. Romero had lied during the course of his interview outside of Lawrence Memorial Hospital. So that again would be a problem. He said that specifically that he didn't know anybody who had shot at them, that a vehicle had followed them across the bridge and was basically almost described a road rage incident. And of course, the video camera, the traffic video cameras show that absolutely wasn't true. So again, we have the issue of the state offering evidence that it knows can't possibly be true given the unbiased evidence of the traffic cameras to show that testimony is not, or that evidence wouldn't have been accurate. And I don't think it is appropriate for the state to, and I don't mean any bad motive in this, but to rely upon cross-examination to correct the introduction of what it knows to be inaccurate information presented in its case in chief.
Well, so you're telling me the state cannot present evidence that of a witness statement made to a police officer, which later proves to be inaccurate, and that is submitted to the jury for a determination, knowing that the evidence may come, but leaving it up to the jury to decide whether the information is inaccurate. I mean, there's all sorts of reasons at trial to present somebody's statement to rebut what they say or to show what kind of witness they are. Isn't that true?
Judge, your statement I would agree with, but in this particular case, the evidence is unquestionable. There's no doubt that Mr. Romero lied to law enforcement when he was interviewed outside of Lawrence Memorial Hospital. In fact, he admitted to that during his preliminary hearing transcript testimony. He testified that it was due to a code that he was following, honor among thieves type of argument. But of course, he also lied and said that the gun that was found in his car was not his. And again, he testified at the preliminary hearing that was false. So again, I think that just the substitution of the interview of him outside of Lawrence Memorial Hospital as a substitute for his preliminary hearing testimony should fail. Now, if there's other reasons to offer that evidence, as you suggest, then that's a different story, but that wasn't ever presented. It was strictly presented as, well, if you're going to exclude the preliminary hearing transcript testimony, then we want to use his interview outside of Lawrence Memorial Hospital. And that's all I wanted to address specifically, unless the court had additional questions.
Thank you, counsel. Mr. Simpson, you have 3 minutes.
Thank you, Your Honor. Just before I get into things, to your point or your question, Judge Malone, I was going to point you to a few cases for the idea that a witness who refuses to testify and is held in contempt is actually unavailable. One such case will be State v. Bailey. That's 292 Can 499, the 2011 case. Another perhaps would be State v. Gleason, 299 Can 1127. That's a 2014 case. And also perhaps State v. Terry, 202 can 599. That's a 1969.
And do you know in all those cases whether the witness was granted use and derivative use immunity? I mean, I can look at it myself, but I just
Well,
ask.
off the top of my head, I don't know if immunity was offered in every case or not.
All right. All right. Well, thank you for those citations. I appreciate it.
So I think the court was onto something here, but what the district court did here was that it essentially judged Romero's preliminary hearing testimony according to its own views on reliability, rather than those the Constitution prescribes. And in doing so, its role was not to weigh the reliability or credibility of Romero's testimony and hearsay. Its only role was to do two things: to determine whether Romero was actually unavailable, and to determine whether Mr. Martinez Diaz had a prior and unrestricted opportunity to cross-examine him.
So if we find both of those are correct, he was unavailable, then there was a prior opportunity for cross-examination on the same fact, same case. What difference does the immunity make to that analysis?
I think the immunity is only relevant to the extent that we're concerned about whether Mr. Romero's preliminary hearing testimony is in fact perjury. I think the fact that he was granted immunity, still refused to testify, tends to indicate that this preliminary hearing testimony on the whole was not perjurious.
You're using this as a inoculation.
Correct. I mean, the grant of immunity, the only purpose of that was so the state could secure his testimony. And the introduction of the preliminary hearing transcript is sort of, the second best alternative for the state. But it has always been the state's intention to produce his live testimony. And in this situation, the court, for whatever reason, either didn't consider that or just didn't allow it. Unless the court has other questions, the state would just ask that the court reverse the district court's exclusion of this evidence and allow the state to present its case.
Thank you, counsel. We appreciate the arguments by both of you, and we'll take the case under advisement and get you a written decision when we can.